This lesson 4 talks about international commercial contracts mostly, meaning business-to-business contracts, and briefly at the end about international business-to-consumer contracts. It also talks about international contract law. Most written business contracts have what's called a choice of forum clause that determines in what location and either in what type of court or in what type of arbitration forum any contract dispute must be resolved. Most written business contracts also have what's called a choice of law clause that determines the international, national, or state law that will be applied by the chosen forum. Most choice of forum clauses choose either a court where one of the parties is located or an experienced business court such as the United States District Court for the Southern District of New York. Most choice of law clauses choose the law of the forum location. If it's the Southern District of New York, it would be the law of the state of New York, or if, like many internet terms of use contracts that you click I agree to when you go to a new website, because many of the internet companies are located in Silicon Valley, it would choose something like, as a forum, the state or federal courts of Santa Clara County, and the law as the forum, and as the applicable chosen law, the law of the state of California. Because companies outside of the United States, to some extent, and outside of the United Kingdom, didn't always want to have their law chosen in the contract with an American or English company as American or English law. The Convention, United Nations Convention on Contracts for the International Sale of Goods was proposed and enacted and has been ratified by many nations, including the U.S., as a country-neutral contract law alternative for international commercial contracts. However, it doesn't cover everything that national or subnational law would cover. It only covers contract formation and enforcement. It does not cover most contract defenses, which are still governed by the party's law, the chosen law, or if they don't choose applicable law, the law that's applied by their chosen forum. Something to remember is that because the United States has ratified the CISG treaty, it automatically applies to any business contract between parties with places of business in different nations that have ratified the CISG. And I said the U.S. is one of those nations. So if a business in the U.S. enters into an international contract with a business, say in Canada, because both the U.S. and Canada have ratified the CISG treaty, it will automatically apply unless, in their choice of law clause, they specifically exclude the CISG from applying. If the CISG applies to a contract by default, or because the parties choose the CISG to apply, they can pick and choose among the CISG rules which they want to apply and which they don't want to apply, except if one of the parties is in a nation that has a version of the CISG treaty that requires written and signed contracts. They cannot get out of that requirement. The good news for American businesses is that the CISG rules are generally similar to the familiar Uniform Commercial Code state sale of goods contract law. But there are some different rules that should be known by parties to international business contracts under the CISG that are different from the UCC rules. The CISG does not specifically talk about electronic contracts as written contracts or electronic signatures as written signatures. However, because one of the versions of the CISG that applies may require written and signed contracts, the CISG has been interpreted by experts as allowing certain types of electronic contracts and signatures to be written and signed contracts for the purposes of a CISG that requires it. And these types of electronic contracts and signatures are defined functionally like the United States Uniform Electronic Transactions Act definitions of electronic contracts and signatures that I talked about in Lesson 2. If they serve the same purpose as printed contracts and signatures, then they're likely to be satisfactory even though they're electronic. Finally, customary international commercial law is also a source of international electronic contract law, and that's talked about extensively in my book. Because it's uncomfortable to many businesses to rely on interpretations of the CISG as to what's an electronic contract and what's not, the United Nations Convention on the Use of Electronic Communications in International Contracts, or the Electronic Contracts Convention for short, was proposed and became effective in 2014, but so far for only 4 ratifying nations, not including the U.S. This sets out detailed treaty-based electronic contract and signature rules. These rules are similar both in part to the CISG contract rules and to the UITA contract rules. The United States is not one of the countries that has ratified the ECC as of yet. Finally, when parties choose a forum for an international business contract or a forum in an intra-United States contract, they can choose a private arbitration forum rather than a government court. When parties choose an arbitration forum for an international business-to-business contract, they often choose the CISG as the law to be applied by that arbitration forum. Alternative dispute resolution includes both arbitration, binding or non-binding, and mediation, which is encouraged negotiation between the parties. The advantages of arbitration have been seen to be privacy, expert decision-making by an arbitrator who can be chosen for their expertise in the relevant type of law or business, and speed and lower cost than court litigation. However, there are disadvantages, as seen by some businesses and parties, and especially consumers. Because arbitration is private, you can't use one arbitration decision as precedent for a future arbitration decision. You can't get any publicity about it if you win. There are no class actions effectively in arbitration, so U.S. consumer lawyers don't like arbitration. As far as business-to-consumer international contracts, there's very little international law that applies right now to those types of contracts. If there is any law in a choice of law clause, it's likely to be the law of the place where the business exists. But the United Nations, the European Union, and the Organization of American States are exploring alternative dispute resolution methods for resolution of international business-to-consumer contract disputes. These are the chapters in my book that relate to what's talked about in this lesson 4. Thank you.